We are standing by in Florida this afternoon, where defendant Sarah Boone is back in court for a motions hearing today.
Boone, who is now representing herself after going through 8 attorneys in just 4 years, is now back asking for more legal help.
Boone is accused of zipping up her boyfriend in a suitcase and then leaving him to die, all while filming large parts of the ordeal.
Now, before we get you back into court, here's more on the case against Sarah Boone.
911, what is the location of your emergency?
It's Monday, February 24th. There's a crisis at the home of Sarah Boone, prompting her to call 911.
Is this a police or medical? My boyfriend is dead. Okay, send a line for the fire department. Do not hang up.
The fire department takes over the call, and for the next few minutes, officials are obtaining critical details about what happened.
No, tell me exactly what happened there.
My boyfriend and I were playing last night, and I put him in a suitcase and we were playing. And it was like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase, so I don't know what happened.
Okay, is he hanging from somewhere or what, ma'am?
No, I pulled him out of the suitcase. I tried giving him CPR.
Fire and rescue instruct Boone on how to give chest compressions.
Just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
31, 32. Please hurry.
Okay, man, they're getting there as fast as they can, okay?
He's stiff and he's purple.
EMS arrived within minutes and advised Boone that her boyfriend, Jorge Torres, had been down too long and there was nothing more they could do. Boone explained she and Torres were drinking the night before and thought it would be funny if he got inside of a suitcase for a game of hide and seek. The next day, deputies returned and arrested Boone and charged her with second-degree murder in Torres's death. Boone's story about a childhood game gone awry unraveled when investigators say they found video on her cell phone showing Boone taunting and laughing at Torres while he was struggling to get out of the suitcase.
I can't breathe, babe.
Oh. That's what I feel like when you drink on me.
Sarah, I
Go.
can't breathe, Sarah.
Yeah. You should probably shut the
When police questioned Boone the next morning, she seemed to have no memory of that happening.
I fell asleep, so I don't know if they suffocated or like had an aneurysm or a heart attack or what.
Boone told investigators she only realized her boyfriend was still in the suitcase when she woke up. Still, investigators say her actions add up to murder. Sarah Boone has pleaded not guilty and maintains her innocence.
And is still looking for an attorney at this
That's
point.
right,
Well, actually,
with a flyer.
she's not. She's going to represent herself. All right, following Torres' death, police spoke with Boone about his injuries, which quickly prompted Boone to go on the defensive. So let's take a listen to some of that interview.
This morning we went to his autopsy, and we were informed of some injuries that he has by the doctor. So so he's got scratch marks to his back.
I know what that's from.
Okay. And it's called a contusion. Do you know what a contusion is? So like basically you're getting hit and then you get a mark from it. You'll get bruising. Like someone hit you or something like that. It's called a contusion. So he had some injuries to his left shoulder. He had a cut near his lip. We could see his mouth was a little.
I haven't laid a hand on him.
Okay.
Also, too, he fell off my son's bike.
Okay.
So I don't know. And he's notorious for running into the wall or the hall tree. So
Okay. What about the scratches? Because there's also sex.
Yes.
Okay. Because there's also like a scratch on the back of his neck, kind of going, but it's going straight across.
I have no idea what that's from.
And they're all recent. They occurred recently. It wasn't something that occurred post or that occurred a week ago or 2 days ago, 3 days ago. They definitely occurred, the night leading up to when he was.
In all honesty, we have not gotten into it.
Okay.
That's why, like, the only thing I thought you guys were going to ask me about, which I was going to be honest with you anyway, are the scratch marks on his back.
Mm-hmm.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house, too, so...
Well, your son was there when? When was he last there?
Oh, gosh.
From my understanding, he was there, like, last Tuesday?
I don't know if it was Tuesday, but yes, he was there last week, so...
Well, we're talking about Sunday.
Yeah.
We're just talking about what occurred Sunday. Because, like I said, the injuries they occurred within that time period.
So you're talking about day before yesterday?
Sunday leading into Monday. You called us yesterday at 1, but the incident, you guys were painting and stuff the night prior.
Correct.
So we're talking about Sunday and then into Monday.
I'm thoroughly confused because we had a good time sitting on the back porch having wine and smoking a couple of cigarettes and then decided to go inside and literally paint, do puzzles, and play and listen to music. That's why nobody got out of sorts. This is what's mind-blowing to me. Like, I have no clue. Nobody laid a hand on anybody.
He also had, like on the left side of his forehead, he had basically bruising, and on like his head and his skull.
I have no idea.
As if something hit him.
I
considered
have not
force
touched him.
trauma.
I have not touched him. I have not touched him.
Then how would you get those injuries?
Tell me and we'll both know. I have not touched him.
Yesterday, when we took photographs of your overall body, and they did the buccal swabs, did they go under your fingernails?
No.
Okay. Are you willing to let us
Absolutely.
swab underneath your fingernails?
Go for it.
Okay.
I have no idea, and I don't want to seem out of sorts, but I have no idea. We had a good day. It was a good day. We've had good days lately, even considering everything that's going on with our jobs and life in general and ex-wives and everything. It's been good. Like, I don't even know where this is coming from.
Yeah,
I
you
don't
said
even
the
know.
last physical was probably, you said, I think, what, a month ago? Where you got the injury, right? You said that was a
I'll
month
say
ago?
a few weeks, give or take, yeah.
A few weeks. That was the last, like, physical altercation between the two of you? You said a month ago he hit you with a curtain rod.
Yeah, with a curtain rod. That's why I can't believe you guys didn't take that either.
Wow.
Like, we've been good. I don't know if, like, it's since the last time he got out of jail. Like, we've been good, and he's been having his classes and seeing his probation officer, who's amazing. So...
What do you mean by good? What's your definition of good?
The probation officer?
No, you said you guys have been good. What's your definition?
I've been good. I don't think you all understand. He comes at me all the time. He comes at me. So it's either I flee or try to go upstairs and go to sleep. That's usually what it is. And I don't know if you talked to Brian about any of that, but most of the time when I flee, I go over there. So...
Right, but you're saying that you guys have been good, and when I asked you yesterday, the last incident that you could remember was the curtain rod incident, which you said was a month ago, so...
Give or take.
Right. So what do you mean by he comes after you? Like...
He gets belligerently drunk. Like, I don't know if you all have looked through my phone yet and seen any of the pictures and the videos that I have taken. And at one point, I started documenting everything.
Okay.
So you all will see in my pictures bloody fingers, split foreheads, he split my nose. I've got this.
Right.
I don't know if Brian told you about it, where I had to have almost I had one really bad surgery, but then it got really, 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 really bad, where I had to go like 4 or 5 more times afterwards for them to tend to it, from him poking me in the back of the leg.
Right.
So it's...
Then why are you still with him?
Everybody asks me that. When I tell you guys this, I really love him, like I do, and I feel like I can help him. Like, I feel like I could help him, which I did, because he came a really long way from where he was in Philadelphia to moving back to here and to dealing with everything else that he's been dealing with. I've really helped him. I bailed him out of jail, 3 times. I've gone to every single hearing and every single arraignment, everything that I did for him.
gone to see all his public defenders, go to the state. I've gone to the state. I did everything for him because I'm trying to help him because I had hope in him. And he was trying. He was really trying. And then he starts to think about things, and I think he gets overwhelmed. And then it's like, the next thing I know, he's drinking. So it's like, oh man, I know where this is going to go. So I'm going to go upstairs and read a book. Or I'm going to go for a bike ride, or I'm going to do something else. Or I don't want to drink. I don't want to drink. The occasional wine, whatever, or if it's a weekend, that's when you have a good time. You don't have to wake up the next day. I have to wake up the next day and do things. I have to tend to Lucas. I have to take him to school. I have all this stuff to do. He doesn't know how to, I guess, maintain himself where I can do 50 things at once and still know the 50 things more prior than I need to get done. He can't process like that. He didn't process like that. So he would literally, not literally, but have smoke coming out of his ears. So the next thing you know, he doesn't want to deal with it. I'm going to go get something to drink. So the majority of the time, I would hang out outside or do something else because I don't want to drink.
Still joining us this hour, criminal defense attorneys Jack Rice, Josh Schiffer. Gentlemen, here's the thing. I'm going to rename Sarah Boone Chatty Cathy because every time we show something, it's either the body cam where she's talking to the police, it's her interview where she's talking to the police, it's the video where she's talking to the video as she's zipped up her boyfriend. Jack, there's so many different versions and statements she's given. Is there any way she can get out of some type of conviction?
This is going to be very, very difficult because the state gets to use all of them. And then what they get to do is they get to compare each against the other. I sat listening to that interrogation, and all of a sudden when she says, oh, then I know what happens next. And all I thought was, this is somebody who's tried to, quote unquote, help again and again and again, and he never seems to get it. That must get frustrating after a while, isn't it, Chatty Cathy? All of a sudden, you start thinking of these various ways to prosecute a case like this. And I imagine as the state watched all of these videos, that's exactly what they were thinking about.
I tell you what, I can't even imagine what it would be like if she actually ends up representing herself, Josh. Could you imagine the opening statement? Could you imagine what that would be like? Could you imagine the back? I mean,
she has a lot to say.
We've seen a little bit, right, with Darrell Brooks, but that was different. He was belligerent and, you know, whatever. But she would just go on and on talking to everybody. So here's my question. A lot of people online are wondering, and they're asking this question, could she really be denied an attorney? We know she's still looking for one, even though the judge said you can't have any public defenders. We know she's still looking for one. Is it possible that really against her wishes, the system, this judge, will make her represent herself provided she can't find another attorney?
They'll appoint standby counsel, but she's foregone, and she's actually already had the ruling about losing public defenders. You have a right to an attorney. No one can force you to use one. And she is the Chatty Cathy. That interrogation is the best example ever of you can't add anything useful to the conversation. Everything you say is going to get turned around. Everything you say, when viewed at a distance, can really look inculpatory. And that's exactly what she's done. She's walking herself into a guaranteed conviction. And I wonder where her brain really is when it comes to what her strategy is. Even people that struggle with what we would consider competency issues or are you know, just out there, they have a belief about what they're doing. And I really don't understand what hers is. She's not trying to stop the trial. She just really appears to not want a lawyer or believes she's going to get whatever benefit by just turning off the lawyer font. And that's not going to happen. This court's eventually going to put her on trial, and I believe the state's going to make quick work of her.
Yeah, what she keeps saying, Judge, is that she can't agree. Like, she doesn't agree with the approach being taken by many of her attorneys.
Right.
She just doesn't agree. Like, she has her own idea of how this case should be handled.
And what does that mean, right? Like,
right, I don't
said,
know what it means.
Yeah, she said, oh, I fell asleep. Well, that's not a defense. You and I were talking about this. She says, oh, I don't drink. Okay, we were drinking. Well, intoxication's not a defense, so we don't know where she's going to go. We do know she's not indicated that she will claim insanity or self-defense as a true defense.
No, and I know there was one dispute with one of the attorneys. He was looking for a domestic violence person, was having trouble finding someone who could come in and testify about the effect of domestic violence, which maybe could have explained her actions that day. That sounds feasible to me.
Yeah, and then I wonder, Jack, really quickly, is she someone who simply is so argumentative because it's not being done the way she wants it done that she can't get out of her own way?
Absolutely. I mean, the Sixth Amendment allows the right to counsel, but she doesn't get the right to decide which public defender that she wants and which public defender is what they're going to argue a certain way. She doesn't have that right. The court has already ruled on that issue. So they will have standby counsel basically there, but they won't be defending her. If she goes pro se, and she absolutely has this constitutional right, this is going to be a very challenging trial for everybody else involved. For the prosecution, I've had to deal with this 20+ years ago. I remember watching judges just sort of turning themselves inside out because they're trying to make sure that every constitutional right is protected, and yet at the same time, some of the things that can roll out of a pro se defendant's mouth, somebody without counsel, can be really extraordinary, and it's very hard to handle and protect their rights at the same time.
You know, I think of Adam Montgomery, and in his case, he didn't even come to court. He didn't even want to be there for his trial versus a Sarah Boone, who I think she will get every word in and is going to be something else to watch.
Yeah.
She won't be quiet.
According to the judge, she forfeited her right to having an attorney appointed by the court. So, you know, we'll just have to see how it shapes up. All right, gentlemen, stand by. We're going to take a break. Coming up, we're getting word that we will have that Sarah Boone hearing at any moment. Believe me, it's on its way in. In the meantime, we're going to preview this, finally have that video from the hearing of Sarah Boone. We're going to begin that next, so don't go anywhere. Keep it here on Court TV, your front row seat to justice.
Hey. Welcome back to Court TV Live. Thank you for joining us. I'm Ashley Wilcott here with Michael Ayala. We are switching gears now to the motions hearing that got underway this morning for Sarah Boone in Florida. On the docket today were several motions filed by the defendant ahead of her trial set to begin October 7th, where she will be defending herself.
Now, Boone was arrested in February of 2020 after her boyfriend Jorge Torres was found dead in a zipped-up suitcase. Now, Boone claimed that his death resulted from a game of hide-and-seek gone wrong, but police decided to arrest her after seeing two troubling videos on her phone showing Boone taunting Torres as he struggled to get out of the luggage, exactly saying to her, "I couldn't breathe." Well, we want to take you inside the courtroom now for the start of today's hearing.
Case number 2020 CF2603, the state of Florida versus Sarah Boone, state.
State of Castro on behalf of the state. William J. for the state.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get your appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial, dated July 18th, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court, dated July 18th, 2024, and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to meet that deadline or at least meet it. So I don't know what I'm supposed to ask for, who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Here we hear Sarah Boone.
Here we go.
Yes, here we go. She is wanting to add information there. We're going to hit that pause button. We're going to have more of her hearing right after the break.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central, only on Court TV.
Tonight on Closing Arguments, she's parted ways with 8 attorneys. Now Sarah Boone is representing herself. We'll have takeaways from today's hearing in the suitcase murder trial.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
All right, back now to Florida and the motions hearing for suitcase murder trial defendant Sarah Boone.
Before we get you back into court, let's bring in criminal defense attorneys Jack Rice, Josh Schiffer. All right, tell us what you think about so far the motion. I mean, I like the way the judge is handling it and talking about, hey, these are the amounts, this is where it's coming from, this is what I'm going to do. Josh.
Yeah, this case is, I just don't even know how it continues to go forward with the way that it is. I'm just sorry, my brain's spinning with something that I just thought about with how she's going to have constitutional challenges to some of these requests and whether there's going to be a fair trial at all here, given the reliance of the court on her as a pro se.
You know what, Jack? I mean, when she's talking about, Chatty Cathy, she had something to say. She essentially said that she hadn't received her discovery, right? And again, the judge did the right thing. He says, when we find out what your witnesses are, et cetera, we'll start dealing with costs then. But then to Josh's point, when you start thinking about the logistics of this, her deposing witnesses, figuring out what witnesses she wants to depose, what issues there are. I mean, it is mind-boggling to think that this thing's going to go forward and actually have a trial date and have a fair trial.
Yeah, I agree. I see all of us stumbling here. I mean, when these happen, when somebody fires their public defender, when they fire their private counsel, and they say they're going to go forward on their own, pro se, what usually you will see is this, is a judge will say, look, we're going to hold you to the standard of a lawyer. The thing is what I've seen this for 25 plus years, they never do. They never really can, because part of what they have to do, what judges have to do, is they also have to protect the constitutional rights of the process, the due process rights of a defendant. And so regularly, they're sort of feeding them information at the same time, which makes it even more complicated. So you're watching this and you're saying, you have to stand up for yourself. You need to understand rules of evidence, rules of criminal procedure, how the process works, the investigatory process, what you're going to do when you're making arguments. I've been training people for 25 years how to do this. This is somebody who's never maybe even seen a criminal trial before, and she's supposed to run this herself. This is just a hint of how difficult this will be.
And it's kind of wild because she's under oath. They swore her in before they even got started. So then you have statements she's making under oath, but only for preliminary matters. It's a wild day in court. On that note, let's get right back in for more of the hearing with Sarah Boone.
No, Your Honor, again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is incenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to stand by counsel as decided by Paul v. State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision, so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's rights away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
I don't want to be pro se. I don't want to represent myself. You heard her say that. You still think the judge has given her sufficient opportunity with 7 appointed attorneys?
I think he's on solid ground for any kind of appeal.
Yeah.
I do.
I don't know if maybe he'll do a standby lawyer out of an abundance of caution. That's a decision he'll have to make.
I think he should.
Yeah, I think so too, but we'll see what happens. Thanks to Jack Rice and Josh Schiffer for joining us today.
Folks, stick around. Coming up, more from that hearing for Sarah Boone. Keep it right here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. We begin this evening with the suitcase murder trial. Defendant Sarah Boone is in court for the second time in a little more than a week since the judge ordered her to represent herself after going through 8 attorneys. Well, the judge is hearing several motions that she filed in her criminal case. Now, in one of the motions that she sent to the Judicial Administrative Commission, she asked for a standby counsel, saying she needs someone to help her prepare for her case. Now, in its response to that request, the commission deferred to the court ruling, saying the court entered an order on June 28, 2024, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel. Now, that issue came up in court during today's hearing, now along with extending the dates for Boone's upcoming trial. Take a listen.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right, so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
All right, let's bring in our guest for this hour. Joining us to discuss, criminal defense attorney, former prosecutor Eric Faddis is with us. Eric, great to see you. Thank you so much for joining me here on the program. So already, we can see the effect of a pro se defendant. We're seeing a trial extended from 2 weeks to 3 weeks. He's talking about moving a pretrial hearing or a pretrial meeting to a different day so that he doesn't have any other cases, so he can really focus in on this case, realizing all the work it's going to take to get this thing rolling on the tracks, ready for trial October 7th.
Yeah, it just shows how consuming a pro se trial can be, not only for the defendant, but for the court, for the prosecution, the witnesses. This is going to be a huge quagmire. And we're already seeing how a lack of defense counsel, Sarah Boone's forfeiture of her right to defense, is going to be a problem. She doesn't know what objections to lodge to these exhibits. She doesn't know what experts to hire. And overall, things are not looking good for Sarah Boone.
You know, it's interesting, I was happy to find out that Prison Break, which is, they're basically investigators that are provided by the state to help out. They're going to be funded, according to the organization that she was petitioning to get funds from. They're going to fund them for $5,000. She'll have $5,000 to procure case documents. But again, it goes back to this idea that even when she gets these case docs, he said she's going to get a USB report from the Prison Break folks. The question is, will she even know what to do with them at that point? And that's what becomes a problem. And here's the thing, if I heard it correctly, and you correct me if I'm wrong, she's not even going to get standby counsel unless she hires one herself. The judge was clear. You are not entitled to any court-appointed personnel.
You know, I think that was maybe not the best ruling that the judge could have handed down. Standby counsel doesn't mean that attorney's going to conduct the trial. The attorney's just there to make sure Sarah Boone doesn't completely sabotage this thing for herself, to give helpful pointers, to give guidance. How are those funds going to be used investigatively? An attorney can give meaningful insight into investigative avenues to pursue. And without that input from a legal professional, Sarah Boone is going to be so hard-pressed to even know what to do with any assistance she receives.
What's interesting is there was some question going into this, and I've been talking to some people online, friends who are interested in this case, a lot of people interested in this case, was the judge just trying to sort of shape her up, that at some point she'd come to the realization, I got to step back a little bit, I need an attorney. She said today clearly, I do not want to be pro se, but the judge said straightforward, I am not going to reverse my ruling. Did that surprise you?
It did surprise me. So the judge's role, in part, is to make sure the proceedings go forth in a fair and expeditious way. And if someone is causing undue delay, the judge does have to kind of try to rein that in. However, we're talking about a right to counsel here, and that's a fundamental constitutional right. And I think Sarah Boone should make another motion in writing to have counsel reappointed and then not fire 7 people who are trying to help her out, because I think that the judge, even despite what he said, could reconsider his ruling out of abundance of caution.
Eric, I got to be honest with you. I don't think he's going to reconsider. I think he was clear. It sounds like he said, I read every word, every letter you sent, and we know there were copious letters, so many letters. He read everything, and I want to get your opinion. It sounded to me like he was done with that whole part of this case. I don't believe at any point, I don't know if he's upset at Sarah Boone or he's pretty much convinced that this is the way it needs to go, but I think he has pretty good cover in terms of any kind of appeal when he went through or allowed her to go through 7 attorneys before reaching this point.
I mean, no question. When you have right to counsel as an indigent person, someone who is in custody, you get appointed a lawyer, but it doesn't mean you have a right to just any counsel you want. If you don't like the public defender, you can just shop around and get another one and another one and another one. That's not going to fly. And the judge really did give her, sometimes judges give a bit of a tongue lashing, like you said, to sort of have a pro se party shape up in court. But the judge would be taking a risk, especially if he does not at least appoint advisory or standby counsel to kind of give Sarah Boone some pointers through this extremely complicated legal proceeding that she's about to go through.
Yeah, I'm not sure unless that comes out of her pocket, any attorneys are going to walk through that door to help Sarah Boone in this case. All right, Eric, stand by. We do need to take a break. When we come back, the issue of discovery of evidence is addressed. We'll bring that to you when Court TV returns.
Court TV fans, you demanded it.
Here we go, do it.
So now you're getting more true crime at nighttime.
Oh my God, oh my God.
48 hours on Court TV tonight, 7/6 Central on Court TV.
Tonight on Closing Arguments, she's parted ways with 8 attorneys. Now Sarah Boone is representing herself. We'll have takeaways from today's hearing in the suitcase murder trial.
Closing Arguments tonight at 8/7 Central, only on Court TV.
We're continuing our coverage in the suitcase murder trial in Florida, where defendant Sarah Boone was in court today for a hearing on several motions that she sent to the court. She's now representing herself after the judge refused to appoint her another attorney after her 8th attorney withdrew from the case. Now we're bringing that hearing to you. It took a while for us to turn that tape around, but we have it now. Here, during this part, they're discussing discovery.
A later time, by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense to me.
That does make sense,
yeah.
And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Yeah. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
Then we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality that is all done in the courtroom with everyone?
It would be in the courtroom, correct.
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail, and I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court.
All right, Boone's trial is scheduled to begin October 7th, and the judge actually extended the trial from 2 weeks to 3 weeks because she's representing herself. Let's bring back in our guest still to discuss, criminal defense attorney, former prosecutor Eric Faddis. And Eric, I gotta say, I gotta chalk one up there for Sarah Boone. She made an interesting comment, and the judge sort of took notice of it and said, I may have to exclude cameras during any kind of evidentiary hearing, not to poison the jury pool. And she raised that issue. She said, what about confidentiality during that evidentiary hearing? That's what any good attorney would have said.
Yeah, I mean, every now and again, she's going to make a decent point, and that's helpful for her. But there are so many things she's potentially missing on this. And I just, when they do this discovery hearing, this evidentiary viewing, it's just going to be extremely difficult. You know, my good friend Joey Cohen, as brilliant as he is, if he went to an evidentiary viewing, he would have no idea what to do, what to look for, what objections to potentially write down. And so those things are going to be difficult for Sarah Boone, a non-legal professional.
Yeah, no doubt about it. Now, you're a former prosecutor. You heard the prosecutor there talking about the way he would handle things. I don't know if you've ever had an opportunity to be in court or with someone who represented themselves, a pro se defendant, but how does that change, do you think, the prosecutor's approach to this case? I mean, they have to sort of be very careful themselves.
Yeah, I mean, well, first off, if I was the prosecutor, I wouldn't be wearing a black trench coat in this Florida courtroom. What is he, like a Batman character? That's a very bizarre outfit. But yes, it absolutely changes things in the sense that you've got to kind of be overly cautious. You've got to kind of give the benefit of the doubt, make accommodations so that if there is a conviction, the reviewing court cannot come back and say, oh, this prosecutor went to lengths to deprive this pro se client of their rights. You kind of have to err on the other side of trying to help out the defendant, which is a weird position to be in as a prosecutor.
Yeah, you know, it's stressful for everyone involved because everyone has to sort of walk on eggshells in that way, making sure that they're really preserving her rights as a pro se defendant. Now, here's the thing. She had a number of attorneys. I think based on some of her letters, she was always worried about the amount of time they were giving her, but there was also issues with the defenses. She felt like they were telling her what defense they thought would work. She necessarily didn't agree. Now, she's charged with second-degree murder, and quickly, I'll just read it. Basically, doing something so dangerous that it's reasonably certain to cause death. There must be some ill will or spite. What do you think is her best approach? Now, she's been claiming this idea, I was drinking, I didn't know that he was going to. That's not going to work. We know that. So where should she go with her defense?
There are a number of avenues that she could consider. One thing that's been successful for some defendants is a battered spouse syndrome type of defense. I know there are allegations of domestic violence on both sides of this relationship, but I don't know if she's been able to retain an expert to talk about that and explain it to the jury. There are also defenses like impaired mental condition, where intoxication can play a role in preventing the defendant from forming the necessary mental state in the case. There are mitigation specialists for if she is convicted that a defense attorney would be enlisting now. I have no evidence that she's doing any of those things, which is going to be make things just that much more difficult in an already hellacious case in terms of the allegations.
You know, one of the motions that were filed in this case by one of the defense attorneys when he was seeking to get out, she didn't seem to like this idea of this domestic violence defense, because he was saying, look, I'm looking for this domestic violence expert to come in. He was having a hard time finding one to be able to come in and talk about the effects of domestic violence, what effect it might have had on her actions in this case. But she didn't necessarily like that defense. That's surprising.
It is surprising, and it sort of goes to what you were saying earlier, Michael, how, you know, oftentimes in a lawyer-client relationship, the lawyer is like, hey, these two options are viable, this third option is not from a legal perspective. And the client says, oh, well, I disagree with you. I want to go with the third option. And so there's a fundamental disagreement between the lawyer and the client, which just erodes the attorney-client relationship. And it sounds like those disagreements have arisen during her discussions with her former 7 or 8 attorneys, however many she said.
Yeah, you know, it's interesting because I think the best approach, if I look at this case as a defense attorney, is trying to get that second-degree murder to a manslaughter, right? If you can get it there, I think that's a win. She's probably not seeing it that way. She's probably saying to herself, I didn't do anything wrong. I didn't mean any of this. I should be walking out. I shouldn't be in any kind of jail. And that might be part of the problem here, getting them to understand that, nah, with that tape and that video, you did something wrong, and they don't want to buy it, and that's what causes some of the problems. Anyway, Eric, stand by. I do want to take a quick break. Now, when we come back, the state continues to address issues of evidence that could be presented in the case. But first, we do have a programming note for you. We don't want you to miss the premiere of Vinnie Politan Investigates tonight at 9 p.m. Eastern. Every weeknight, Vinnie takes a deep dive into the true crime stories making headlines across the nation and asks the hard questions. Tonight, Vinnie takes you inside the investigation into the Idaho student murders and the case against Brian Koberger. Kaylee Gonsalves' parents join Vinnie live. Don't miss the premiere of Vinnie Politan Investigates right here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. We want to turn back to the suitcase murder trial hearing in Florida. Defendant Sarah Boone was in court today for a hearing on several motions. The judge has extended her trial from 2 weeks to 3 weeks, and it's set to begin on October 7th. Now, we've been covering today's hearing. Right now, they're addressing some of the evidence that the state plans to show in court.
That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open. In the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it, the conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use, these are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use, and then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial, and either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go as answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever we deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that I cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings.
All right, so clearly the procedure for viewing evidence has to change for an incarcerated pro se defendant. That's what they're discussing. Also, Sarah Boone wants to limit some of the media coverage of her case. She'll address that with the judge when Court TV Live returns. Defendant Sarah Boone was in court for a hearing today to address several motions. Now, the motions have included a request by her to have some of the costs of her expenses and her defense covered by the court. Well, now she's asking the judge to keep the media out of some of those hearings.
In court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive and research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, if the USB drive or the after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. And I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing the list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of the discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, okay, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered. Thank you.
Your Honor, I feel uncomfortable when you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but.
All right, let's bring back in our guest, still with us, criminal defense attorney, former prosecutor Eric Faddis. Eric, first impression, and look, it's very early in the process, but I'm fairly impressed by Sarah Boone, her questions, the things she's talking about. She seems to understand what's going on and what's needed.
Yeah, I am too. I got to admit, she's made at least a few colorably meritorious arguments where she's asking to limit the media for this hearing that's going to discuss evidence that may be inadmissible. That's a good argument. And that's what a defense attorney would make. They would say, hey, we don't want the media hearing about evidence that could be inadmissible because it could taint the process, potentially taint the jurors, and that one was a potential win for Sarah Boone.
Yeah, no doubt about it. It's not something everyone thinks about. She was right on point with that, so we got to give her definitely a check in that column. This issue of evidence viewing and its procedures, explain to our viewers, you've been on both sides of this, what normally happens versus what has to happen in this case, because again, she's an incarcerated defendant representing herself.
Oftentimes, when there are attorneys on both sides, they will pick a place to review physical evidence that might be offered at a trial. So, for example, in this case, it might be the suitcase. It might be other phones, other physical evidence. And they would meet somewhere, usually a police department, district attorney's office. There would be people from both sides present, and they would review the evidence and make notes and decide how they want to further their investigation. Here, what they're going to do instead is have Sarah Boone kind of not totally by herself. There will be other people there watching what she's doing because they don't want her tampering with any physical evidence, but it's going to be an augmented process, not something the court is used to, and you could kind of hear the court struggling here and there with issues in terms of how it's going to address this evidence viewing and a follow-up hearing.
And at the end of the day, the way the judge seemed to put it out there is that he wants to do it in open court to make sure that there's a record of the fact that she's seen it. Because if they turn this stuff over to her and put it, send it over to jail, which would be a problem, wherever she's being held, there's no way of them really knowing that she's looked at the things she needs to look at and had the proper opportunity to examine it all.
Exactly. I mean, she has a due process right, among other rights, that entail her being allowed to review this evidence in person. And so the court is kind of going out of its way to make sure that she gets that opportunity. And that was just another one of those accommodations we talked about for pro se clients. Another one is that they're going to have part of this be sort of secret under the guise of plea negotiations. But they're not talking about resolving the case. They're not talking about plea offers. They're talking about the evidence. And so they're just a number of accommodations that it looks like the government is making on Sarah Boone's behalf.
I want to check back on something I mentioned earlier about this second-degree murder charge, and I suggested that it would be a victory for a defense attorney in this case to get it reduced to, let's say, manslaughter. And I'll just quickly read. Maybe the manslaughter is basically where you do something, you're not trying to cause death, although what you did is intentional, but you're not trying to cause death, and the death is not reasonably likely. Now, the reason why I'm saying that would be a victory is because with the video where you have Jorge saying, "I can't breathe," I think it makes it difficult to convince a jury that she walks away from him not with the idea that it might be reasonable that he could die in there because he said he couldn't breathe.
Yeah, there are a number of other charges. Sometimes we call them lesser included or lesser non-included that she could pursue to try to convince this jury of that would substantially lessen the sentencing range that she would face.
Yeah, I think ultimately with her, intoxication, et cetera, there's a chance that a good attorney could get this reduced down to a manslaughter conviction. So anyway, Eric Faddis, thank you so much for being with me this last hour. Real pleasure to have you on the show.